People of the State of New York versus Robert Neulander.
May it please the Court.
Good afternoon.
I'm James Maxwell, appearing for the people. I'd ask for 2 minutes of rebuttal time, please.
Certainly.
Thank you.
Welcome.
The Appellate Division 4th Department majority in this case erred as a matter of law when it reversed the trial court's 330.30 decision and granted the defendant a new trial. This is a case where the juror in question, juror number 12, was not shown to be impartial, and the 4th Department majority didn't stop short of requiring the defendant to meet that burden, and that was error.
Mr. Maxwell, it's a difficult case, and one of the things I struggle with, when you go through the text messages in the case, they don't seem to be dispositive one way or the other. The issue, though, and the way I read the 4th Department decision was that it was the concealment of the communication that had taken place and then lying under oath. Those are the things that I think were ultimately dispositive in their decision.
And I have problems with that in terms of the fact that under 330.32, by definition, the juror misconduct must be misconduct during the trial. And they instead elevate to a substantial right those two things you just mentioned that were after the trial. I think the correct approach was the trial court's approach, which was to look at everything and decide whether those post-trial indiscretions were of such a nature as to cause the court to have to find for the defendant, and they weren't.
So, counsel, how does the court assess the impact of all these things on the juror's impartiality when the juror is not particularly honest and forthcoming with the court?
Well, again, that's the nature of a 330.30, that the information is not known during the trial. So that's built into the equation. Her failure to come forward during the trial is not itself a substantial right. And then to compound the error from the 4th Department is they went to the wrong statute. They started talking about 270-35 with the idea that the defendant lost a chance to challenge the juror during the trial. Well, that's similar to an argument that this court rejected in People versus Rodriguez, where the defendant tried to get a look back to jury selection when a juror in that case failed to disclose that he knew an assistant DA in the office that was prosecuting the case.
Aren't you saying that this is ultimately a credibility determination on the part of the trial judge, or in this case was on the part of the trial judge?
Well, he had a valid basis for a credibility determination, but what I'm saying is that should have been given due deference.
Okay.
But that beyond that, the 4th Department committed multiple errors in reviewing that decision. That they elevated things to a substantial right and didn't hold the defendant to his burden. For example, there are cases where this court has found something so inherently wrong that the defendant doesn't have to show actual prejudice. Crime scene visits, experiments, Brown, Crimmins. That is not this case.
So is there a distinction between lying or covering up in order with the purpose of affecting the jury verdict?
Oh, it would be completely different, yes.
Okay.
Yeah,
And what's the difference?
Well, here, I mean, her covering up, I think she's showing some after the fact, have I done something wrong? And it really shouldn't be up to her to decide whether she did something wrong. It should be up to the courts. And as opposed to during the trial,
Well, she knew that lying was doing something wrong,
Well,
presumably, so.
well,
I mean,
Not following the directive of the court is doing something wrong.
Are there innocent explanations for lying?
well, again, I think that's putting it too strongly. I think when she was asked during the trial by the court directly, have you discussed the particulars of the case? And she said no, that wasn't a lie. She believed that she had not discussed the
How do we
particulars
know
of the
that?
case.
How do we know that? Because then, after the trial, she goes and deletes things that she describes as problematic and deletes the entirety of her browsing history.
Well, again, the browser history, the court below found, and the appellate division didn't dispute, that there was no finding that she did anything improper when she was browsing. The beginning of your question was, I've lost it, I'm sorry.
Sure. It essentially goes back to where you started, which is you were drawing a dichotomy between what happened at trial and what happened after the trial. And it seems to me the question here really is, when there is substantial information about conduct of the juror that happens after the trial directly related to what she did at the trial, doesn't that really then impugn things like the statement she made that, no, I haven't done anything wrong?
Well, I think
How do we then believe her?
I think that puts it in the trial courts. That's what trial courts do. They can believe some of what a witness says and not believe some of what a witness says. And that's what the judge did here, discerned it. And when we look at what she deleted.
And the appellate division has the power to refine that.
But what they did is they committed multiple errors in reviewing the judge's decision. And the things that she deleted really show, many of them show that she was doing her job correctly. The final, I think it's exchange number 36, during deliberations, the night before they reach a verdict, she deleted this entire thing. It shows that she was undecided. It shows she was agonizing over it. It shows that she was doing what jurors are supposed to do. And she's not revealing, and none of the record shows that any of these things that were said to her during the trial had anything to do with the issues at trial.
Does it matter whether the appellate division here found as a matter of law that there was an abuse of the trial court's discretion versus whether the appellate division was exercising its own discretion and making its own credibility determinations?
Yes, and the former is the case here. They say that right at the beginning of their decision. And I think that's where we have an error of law that this court should correct, similar to People versus Testa, which was a third department decision.
So you're saying they weren't making a credibility determination?
No, I'm saying they made a series of errors of law. And to the extent that you say that they were making a credibility determination, I just don't, I see the errors as the problem.
The reason I ask is because if the trial court made a credibility determination and the appellate division made a different credibility determination, then I'm not sure we'd have the power of review over that. That's why I'm asking the question.
But Your Honor, what they did was they never reached whether the defendant had to show actual prejudice. And that was error.
Well, that's the nub of this. The language of the statute says may have affected a substantial right of defendant. And that word may doesn't mean actual prejudice. That means, is there a scenario under which this could have been prejudicial? And that's why we go back to concealment.
Can I give two answers to that, if I may? One is that word may has been in there right along when this court said in Rodriguez and Irizarry that absent a showing of prejudice to a substantial right, the defendant is not entitled to a new trial. And italicizing the word may doesn't give the Fourth Department license to...
No, but it is there.
No, it is there.
And may is different than actual prejudice or must have affected. It's a much different analysis that we will go through. It seems like, is there any reasonable possibility? I guess that's the way I do it.
Sorry.
No, go
Following
ahead.
up on that,
Yes.
because it's about this, whether you want to enforce this conviction or uphold this conviction, where there's a specter that is over, shadowing this, that you had a juror who's clearly not following instruction. And that's clearly demonstrated in this record. She's not following instructions. And that, I think, is what the concern is of the Fourth Department. And you know, it goes to the whole integrity of the process.
But the specter, though, during the trial, the messages show that she was following the instructions to not just talk about the case. We can't talk about this case. I'll talk to you when it's all over.
That, I think, going back to, I think, what Judge Wilson pointed out earlier is, I mean, well, and Judge Feynman, you have the right to a juror who's going to decide this case on the law, and the judge gives it to him, and the facts as they're developed at trial, and the witnesses, and she erased her browser history. So, one, I think that shows some consciousness that there was something in there you want people to see. And two, how will we ever know now that they got that the defendant here was given a juror who didn't go out and browse and look at the crime scene and look at other photos and look at other information. And there's a very clear inference here that, you know, that was deleted for a reason, combined with the fact that you're deleting internal texts within a conversation. I mean, it's a pretty tough
Again, Your
set
Honor,
of facts
she
to overcome.
also deleted information that, once looked at, demonstrated that she was following the judge's instructions about not discussing the case. And this information that she was presented from these three sources had nothing to do with the issues at trial.
May I just fact check something to make sure I've got it right? That after the alternate juror submitted her affidavit and that was brought to the people's attention, the people met with juror number 12 and she presented printouts of the texts to you during a meeting, and those were the expurgated versions of the texts, and she didn't disclose to you that things had been removed. Is that right?
What we were doing at that point is trying to answer the accusation
Yes, I just
about
wanna know
whether
this-
she got media alerts.
Right.
And so she presented the information that showed she got a screenshot as opposed to a media alert. And
Right. I'm not asking.
but I'm not
right.
disputing the facts.
No, I'm just trying to ask if there was a point in time before I think you tendered her affidavit, juror number 12's affidavit to the court. There was a point in time before that affidavit was finalized that you met with her and that she produced to you some version of these text messages that was not the complete version of the text messages, and she did not disclose to you that she had removed the text from those messages. Is
Yes.
that right?
Yes, but what I'm saying is the issue with what she presented to us was to answer that particular issue that's really not an issue now, which is, was she getting media alerts? No, she wasn't. Somebody sent her a screenshot.
All I'm really asking is when you tendered the affidavit to the court, you did not know that the attached text messages had deletions that were not evidenced on the face.
Correct, correct. Okay. And again, to look at the information she was
Counsel,
presented.
it's much of what Judge Feynman and Judge Garcia have been pointing out to you. I'm having difficulty understanding how your position and the rule that you're promoting, the standard you're promoting, promotes public confidence, not just in this verdict, but in the jury system. When you have a juror who, even the lower court said, and I'm not talking about the appellate division, the trial court says, her actions show a consciousness of misconduct. Even if you don't want to use the word lying, she has at a minimum shaded her version of what has occurred and attempted to cover her tracks. It makes it very difficult for anyone on the street to say, yeah, you get a fair shake when you go in front of a jury, when you have a juror that's conducting themselves in this way.
Well, again,
And then the court say nothing about it or say, no, that's okay.
I beg to differ in that the trial judge made his determination, and he didn't find totally one way or the other. He did what hearing courts do. He discerned what the facts were, and he discerned the legal effect of those facts. And the fact that after the fact, she engaged in some conduct that didn't make her look very good does not retroactively mean that she committed substantial misconduct during the trial. It's just the opposite.
Right, but
as shown
that's
from the
against
messages.
judge deciding it's not substantial misconduct because I don't think it affected what she did during deliberations. And again, we're left with how can anyone really trust that without knowing fully what the record is, given her conduct?
Well, we had a full record, we had a very exhaustive hearing, and there is no evidence that she was anything but an impartial juror during the trial.
Thank you, counsel. Counsel?
May it please the court. My name is Alexandra Shapiro, and I represent respondent Robert Neulander. I think some of your Honor's questions have got at the real fundamental issue in this case, which is that because of the fraud and lies and deceit perpetrated by juror number 12, there is simply no way to know both the extent of outside influence and whether she followed the instructions. And indeed, with respect to the latter, I think her repeated violations of not only the instructions not to interact with third parties and access the media, but also the court repeatedly told the jurors that if they were contacted by a third party, they had to report that to the court. And she not only did not do so, but during the inquiry hid that.
Counsel, what about this suggestion here that at the bottom, this is a credibility determination? The trial court looked at all of this, factored in these lies/misrepresentations, the deleted browser history, and then made these credibility determinations based on everything the trial judge had heard that this type of influence didn't occur.
Well, Your Honor, with respect, I think that the only thing that really supported that was the juror's own self-serving testimony, and this court and other appellate courts in New York have repeatedly said that that is not at all dispositive.
Well, are you talking about the access to the web? Because if you're talking about her texts, it's not just her own word. It's supported by those texts. I mean, I have a hard time finding anything in the text that indicate bias. So we're sort of saying what we don't know. Well, and my concern about all of this is that are we really saying that every time a juror is not completely honest about his or her conduct, that's a presumption of bias, and we're going to overturn convictions?
No, not at all, Your Honor. And indeed, this court has repeatedly held that there is no ironclad rule for these types of determinations, and that it's a case-by-case inquiry.
So if that's true, why do we not defer to the trial judge's determination unless it's an abuse of discretion as a matter of law? And I don't see how this is an abuse of discretion as a matter of law, other than the question of her lying.
Well,
if that's what you're saying, it is.
I am saying that, and it's because of the extent of the lying in the particular circumstances. And if I can just get back to what we don't know,
But could you, in response to that, also, although they say that they have reversed this on the law, when you actually look at the decision, read it, because we do sometimes look behind those characterizations and say that this is really a reversal on the law and the facts, and then
I think
that sort of changes.
You could certainly say that
power.
because it is certainly clear that the appellate division had a different interpretation of the significance of the evidence before the trial court and the significance of the juror's testimony and whatever was in those texts. So you could say that, but I think it's really important to emphasize that what we don't know is not only, with respect to the text, we don't know what other texts the woman was engaging in. She did, as came out in the discussion with Judge Wilson, give selective versions of her text to the prosecutors when she was specifically asked about all of this.
I may be wrong. Weren't they able to, in their forensic analysis, weren't they able to to get the texts, at least, that she hadn't disclosed?
Texts were recovered, but we don't know what wasn't recovered. Forensic analysis is not a perfect thing. And with respect to the internet sites, I want to emphasize two things. Number one, they were able to recover these cookies, even though she had deleted the browser history. It's unclear whether those are complete or not, but they showed that she was on 2 different days accessing 2 different news websites that had coverage of the case. And with respect to one of those, the Syracuse.com, she said she believed, she recalled that she was looking at a cheerleader article, and the evidence showed there was no cheerleader article, published that day.
I remember that in the record. Is there anything in the record, in the texts that are in the record, that you would point to as signs of bias or prejudice?
Well, certainly, and indeed, even the dissent.
Specifically, what's in there? What do you point to?
Well, the father, excuse me, I'm sorry.
The father's statements, right, but she didn't agree with them.
We don't know whether she did or not. She didn't respond.
I see.
She didn't respond. The one friend.
So are we establishing, would we be establishing, from a practical point of view, an impossible standard? My wife's on the jury. She comes home. I said, how'd it go today? She said, I can't talk to you about it. Well, but if she says fine, then she's violating the juror code.
No, Your Honor.
Okay.
With respect, so I can go through each of the texts, but
I don't want you to do that. I just want you to point to the ones that you thought are valid. But we got to understand the rule that we may be creating here, and I want to be clear about it. Are we creating a rule? Because it seemed that text messaging in any form by a juror discussing a trial in any way is automatically a juror misconduct.
No, Your Honor, and for several reasons. First of all, I think this court has repeatedly held that you have to look at the totality of the circumstances, and so you can't just consider one. If in a case like this, you wouldn't just look at each thing in isolation, and we would not, and nor do we need to argue that one particular exchange is the problem.
But isn't that what the court did here? Isn't that exactly what the trial court did here? Looked at the totality of the circumstances, acknowledged, recognized that we didn't have everything, looked at the burden, but looked at the text messages, looked at what proof there was, looked at her testimony, and weighed all of that and decided that it wasn't.
No, Your Honor, my point is a different one, and I think the trial court did exactly the opposite, and one of its legal errors was that it didn't, that instead what it did was it looked at each piece of evidence in isolation instead of looking at the entire picture and instead of taking account of the lies in their full. And I do want to point out that although my adversary...
It could be argued that what you're saying is put all that other stuff aside and only look at the fact that she was not truthful. So that could be viewed
I don't
as
think
not
so,
looking
Your
at
Honor,
the
because we have not only the fact that she wasn't truthful, we have the fact that she repeatedly violated the trial court's instructions. And how can this court have confidence and issue a holding that says it's okay?
It really comes down to the charge that you give every jury. False in one thing, false in everything. The falseness in uno charge, and isn't that your argument?
Well, that's part of the argument, certainly, that we just simply can't have confidence that she followed instructions when she clearly...
What about the distinction that Mr. Maxwell makes about during the trial interactions and her post-trial behavior?
Well, I was actually getting to that. I don't think it's accurate for several reasons. Number one, there was an in-chambers conference with the court during deliberations in which the juror was asked whether she had conversations with an alternate juror about the case, and there's a credibility dispute there that was never resolved. But she was also asked, did you have discussions with anyone else? And she said no. And so that occurred during the trial. That was at a time where a further inquiry could have been conducted and more information could have come out, and perhaps the situation could have been cured, or the defendant could have exercised his right to try to argue that that the juror should be removed. But none of that was able to happen because during the deliberations, she failed to disclose it. Moreover, although we don't know exactly when she deleted all these texts and destroyed all this evidence, it clearly must have happened during the trial. And so we know that during the trial, she was repeatedly violating the instructions and deleting evidence. The other thing about the texts in particular that I want to emphasize two other things. One is that we don't just have a situation, as occurs in some of the other cases that are cited, where there isn't dishonesty, where, you know, someone's on Facebook and somebody posts something and the juror doesn't respond. Here we have a juror who's actively engaging with these friends, even though she didn't respond to the father's text. She actively engages and responds to the other texts, including the text from Flanagan about the key defense witness, Jenna Neulander. She's sending these hear no evil, see no evil emoticons.
But her responses didn't show any bias, did they? The responses
I
that we
think
have?
that the point here is that maybe if all you had is the text, maybe this verdict should have stood, but
That's what I was gonna ask you.
That's not this case.
That's what I was
This
gonna
case
ask you,
has
though, is
much more.
If we put aside the browsing history, and she conducted all the text messaging that she did, and then was entirely forthcoming about it. So when interviewed in camera, she said, yes, I have text messages, handed her phone over to the judge and looked at everything. Do we really, in that circumstance,
I think that would be a very
that's-
different case,
It
Your
would be a
Honor.
very different case.
Very
Would
different
it be on
case.
the other side of the line, do you think?
And I think that may well, the verdict could stand if those had been the facts, if the juror had been forthcoming.
I want to be clear, though, you know, and I think Judge Fahey was asking about this earlier, which is, how do we articulate a rule for trial judges to enforce? Like, you know, how do you articulate how they decide when it's over the line or not over the line?
Well,
Or they just know it when they see it?
I actually think that the appellate division's core holding is pretty on point, and it's a very narrow one. They said, every defendant has a right to be tried by jurors who follow the court's instructions, do not lie in sworn affidavits about their misconduct during the trial, and do not make substantial efforts to conceal and erase their misconduct when the court conducts an inquiry with respect thereto. These rights are substantial and fundamental to the fair and impartial administration of a criminal trial. And I think that's the fundamental point here.
But if those violations have nothing to do, they're just embarrassing. Let's say you're having an affair, and your texts are with your lover, and you lie about all of that. You still think that person,
Well, I think
that's juror misconduct, they
that-
shouldn't serve on the jury?
that if that's not related to the trial, that's not what we're talking about here.
Exactly.
And I think here.
So all I'm saying is the point about the covering up the lying, it's still even narrower. It's as related to the trial, not about something personal that you may be engaged in. That's irrespective of the
If it's
trial.
about something personal, unrelated to the trial, then of course not. But that's not the case
Unless you think
here.
it's reflecting an inability to be truthful and honest, and maybe you have other concerns about
It
that
might
juror.
be, so you might have an extreme case where it turned out the juror had concealed, for example, a personal relationship with a key witness or a party or
Those
something like
cases
that.
are kind of obvious, yes.
But putting that aside, if it's completely irrelevant to the trial, I mean, keep in mind that one of the many lies here was in the sworn affidavit. She said, at all times, I followed the judge's instructions, which is the critical question here in many ways.
Well, what if, just getting back to the text for a minute, what if every single text that came from a third party, her response was, I can't talk about it until the trial is over, I have no opinion, and so on? Is that misconduct?
If that's all there was, and she didn't, lie to the court about those communications when inquired into it,
No, I'm not talking
perhaps
about the
not.
lies, I'm talking about the texts themselves.
But I guess my point is that,
Because she might very well think that was not disobeying the court's
but how would you know? There's no way to know, and there's no way to know whether she was reading articles about the case. She may well have been reading articles. This case,
No, I'm not asking about this case. I'm focusing in
general.
on the rule in general, yes.
well, I just,
Because what concerns me partially is that everybody has a cell phone now. And, are we going to be interfering with a lot of trials and a lot of verdicts if we if we basically say, and if somebody contacts you about the trial, then that's it. That's misconduct.
Or, when you answer that, what I'm concerned about too, on the same answer, is the intrusiveness of this proceeding. Because you have a jury verdict, people come and they serve and and now we're going to forensically examine your phone, so what, and you're going to testify, and now you're lying, and what is the standard if we rule the way the appellate division, if we affirm that, for the next lawyer to come in and say, I want the phone. I want a forensic examination of the phone. Because somebody contacted them, they may lie about it, let's go for the phones.
Well,
and now we're going to have
I think
this
there would have to
proceeding
be a showing, and there was here, because an alternate juror came in and said that this juror in question had been looking at media alerts in her phones and there was some evidence from which to.
media alert, and it turns out it pops up on your phone, and now we're going to take your phone and do a forensic
No,
exam?
but what happened here was, there was more than that in terms of the conversation that was alleged by the alternate juror. So I think,
I thought the media alert had to do with the jurors being selected or something.
well, there were, I don't think this is really before the court, but in the sense that the alternate juror made a number of allegations about the juror having discussed the case with her during deliberations. The juror disputed some of that. The trial court did not resolve most of those disputes, although he did rule that actually the juror was not accurate in terms of the media alert thing. What happened was the juror claimed that it was an innocuous text from another individual who's not mentioned in these appellate papers, and the trial court determined that was not true. And in fact, it was an exchange with one of the individuals here, Flanagan. So, but we are certainly not advocating, nor does this court need to adopt some kind of broad rule that would open the floodgates to inquiries into what's on a juror's phone. I think the bar is got to be set a lot higher in terms of what constitutes misconduct. And I think what happened here just is way beyond the pale. I'm not aware of any case remotely like this except for a couple of federal cases. I haven't seen any case in this state where there was this level or anything even remotely approaching it in terms of dishonesty when questioned. And
Let me ask you this. I mean, we're
Supreme
focused
Court-
on the social media for all the obvious reasons. There is real concern. These are
Sure.
real issues about what to do with the fact that people are so very comfortable with social media or these kinds of interactions. But if this didn't involve her cell phone, if she was doing this face-to-face, I assume you'd take the same position. If she was talking to people or they were talking to her before the trial, on her lunch break, or when she went home,
You mean?
you would take the same position, would you not? Because
Sure.
you'd come back and have lied to the judge, no, I didn't talk to
course.
anyone when she had.
Yes.
So it is a mode of communication, but the point is the communication.
The point is the communication coupled
cover-up.
with the dishonesty and the fraud on the court, really.
Thank you, counsel.
Thank you.
Counsel?
Just to follow up on some of these things, what I think is beyond the pale is to grant someone a new trial when there's been no showing of prejudice. And to make a rule where we're going to be giving new trials when a trial court has found
Well,
there's
but does
no
the
showing of
statute
prejudice.
actually require that?
I'm sorry, I didn't hear the beginning.
We go back then to the language of the statute. Does it require that?
I
Actual
believe,
prejudice
I believe the
standard?
way it's worded and the way it's been interpreted by this court, unless you have one of these inherently prejudicial situations, such as a crime scene visit or an experiment, unless you have that, you're in a situation where a defendant, by preponderance of the evidence, has to show prejudice. And
Prejudice in what way? Are you now talking about harmless error analysis?
I'm talking about not harmless error, but whether the error was harmful, whether the defendant
Well,
was...
isn't that the flip side of harmless error?
Well, I'm saying that
And haven't we said that this sort of thing is not subject to that kind of analysis?
actually, some of your cases indicate that in a given case, you're not going to go to harmless error, but it doesn't rule it out. But what I'm saying is, and I don't mean to be drawing too fine a distinction, but rather than straight harmless error analysis, I'm saying that the harm or prejudice is not here, because the proof, the issues in the case, are completely different than the information that was in the text, that there's no overlap. No one,
What about the argument that what's really critical is following the court's instructions? And if someone doesn't follow the court's instructions and then lies about it, how can we be confident that they were impartial jurors?
we can be confident because the trial court had a thorough hearing. That not following the instructions is simply what creates the issue, presents the issue. Looking at the texts themselves and the testimony and the hearing resolves the issue.
So let me ask you a different question, and maybe it's not a fair question for your side, but let's say we don't agree with you and we do think that there should be an affirmance. How would you formulate the rule so that we're not opening up the floodgates?
Well, I suppose any case can be limited to facts, but again, the situation here invites defense attorneys to get a verdict and then launch onto a new string of litigation. This is kind of a fluke that there even was a hearing because they're all generated by the alternate juror.
Isn't there some
Right,
point
and so, I mean, it's not going to
unusual.
be every case.
But maybe now it will be if the rule is such that any showing that a juror, faced with her privacy being invaded, we have exchange number 8, which shows.
That's why I'm trying to give you an opportunity, if you were to end up on the losing side of this case, to have input into the formulation of the rule.
Well,
so
I
that
think
it doesn't.
Well, I think any rule has to go back to the defendant still has a burden to demonstrate that that the juror was not impartial.
Isn't there some point where injury to the system itself is great enough that we shouldn't require a defendant to show injury to the defendant? And let me give you an example. I've been summoned, well, I'm going to be summoned for jury duty in November or so. And let's suppose I show up and I say, my name is Gene Fahey, I live in Buffalo, I give a completely false description of who I am, and I'm impaneled on the jury, and that doesn't surface until later.
Mm-hmm.
Juror may not have been, well, might have been, but may not have been prejudiced by that.
Mm-hmm.
But it seems like the system shouldn't tolerate that sort of thing, no?
And, Your Honor, I think that that's illustrated by Crimmins, by Brown, where there's something that's so fundamental that it's inherently prejudicial. That is not this case. This is not inherently prejudicial. It's not even prejudicial at all when you look at the information she receives. She receives information about whether the defendant's daughter should be a suspect. Well, again, any information that anyone other than the defendant is a suspect is arguably exculpatory. But in the context of this case, it just shows that this Lindsay Flanagan just didn't know what she was talking about. The other friend saying, is he scary? Well, again, that has nothing to do with the issues at the trial. It's not like they came up and said, what about those red neurons? That this is how it works. So here's how rigor mortis works, or here's how vertigo works. This is not those cases.
Bias works itself in such strange and varied ways. The constant onslaught of the disbelief in the veracity of the defendant's version of the stories, the constant reaction to what is going on in the courthouse, the father saying, make sure you find him guilty.
Well, again.
And then you lie about it, you cover it up, you delete it.
Well,
Again, I go back to my other question, how does that promote confidence? Very much what Judge Wilson is asking. How does that promote confidence, not just in this verdict, but in our system, in our jury system?
But how does it promote confidence?
I mean, I think you would agree that if when she was in the veneer and she was asked, can you follow my directions? And she said no. Sounds like a good cause strike there. Do you not agree?
But, Your Honor, she didn't come to this trying to lie her way onto the jury. She didn't particularly want to be on this jury.
But one could certainly look at her conduct as an attempt to stay on the jury by covering it up, by never telling the judge, I had these contacts today.
Well, again, what happened during the trial, she was specifically asked, did you discuss the particulars of the case? She said no. That was accurate. We know that was accurate, not because of her testimony, not just because of her testimony after the fact. We know it from looking at the text messages. They don't involve the particulars of the case. They don't involve the issues of the case. Fourth Department said
Are
otherwise.
you busy deleting things?
That's her phone. She was not under any order to not delete anything. And who knows why people delete. And much of what she deleted, once it was uncovered and looked at, shows that she was conscientiously doing her job
One
as a
more
juror.
reason not to delete.
Again, it's her phone. Are we going to make a rule that puts jurors through what she was put through? And
Well, it certainly would be a deterrent, would it not?
Be a
To
deterrent if you want
violating
to
the
be on a
judge's
jury.
rules. So
I
it
know
might be a
Judge-
very good rule.
Judge Wilson may want to keep that in mind in a couple of weeks. Lucky you, as the dad would
Not
say.
right, not
But she
right.
didn't even remember the exchange with the dad. She didn't see, there'd be no reason for her to see anything against the defendant in any of the information. It's not like she was given information about the case or information that was inculpatory towards the defendant, excluded evidence. That's not this case. And to give a new trial to a defendant who has not shown that the juror was anything but impartial is wrong.
Thank you, Mr. Maxwell.